The Court of Justice has adjourned its proceedings late Wednesday afternoon after hearing extensive arguments by several attorneys in the matter Irfaan Ali and others versus Eslin David et al. In making his submissions on behalf of the PPPC, Attorney-at-Law Douglas Mendez argued that the learned judges of the CCJ would have to find that the court has jurisdiction to preside over the matter.
That you must have jurisdiction to determine the jurisdiction of the Court of Appeal when it is exercising a limited jurisdiction. And under 177.4, that jurisdiction is very closely defined. It's not a jurisdiction at large. It's a jurisdiction that is clearly defined, as I've indicated. It must be a question as to validity of an election, and that question must depend upon two things. If it depends upon anything else, 177.4 simply does not apply.
In seeking release from the court, the attorney asked that the appeal before it, that is the CCJ, be allowed and that the recent ruling of the Court of Appeal be overturned since it did not have authority to make any pronouncements in the case. As a consequential order, the attorney sought to have the recent elections report submitted by the Chief Elections Officer of GCOM retracted.
I ask you to make consequential orders to require him to withdraw that report, and then everything else would take its course thereafter. GCOM will require whatever report it needs from him, and it will then declare the election in accordance with the report that is produced, presumably in accordance with the recount.
Attorney-at-Law Ralph Ramkaran reiterated that the elections report by the Chief Elections Officer should be null and void since it seems to be of his own imagination. Further, the attorney asks that the court determine what are the valid votes of the election, which should form the basis of the final declaration of results.
I would respectfully seek your intervention in going a step further and not only ruling, not only setting aside the Court of Appeal's decision, and ruling the direct consequence of that decision, namely the letter of the Chief Election Officer of June the 23rd to be null and void. I respectfully seek Your Honor's intervention to say what are the valid results of these elections.
Meanwhile, Attorney-at-Law Justin Simon, who appeared in collaboration with the Attorney General for the respondents, submitted arguments to the effect that the Court of Appeal had jurisdiction to rule in the matter based on Article 177.4 of the Constitution of Guyana, and further, that the Caribbean Court of Justice does not have jurisdiction to hear the matter under Act 16 of 2004 of the Caribbean Court of Justice Act, Paragraph 3, Section 4. The attorney, in attempting to persuade the court that an election petition would infringe on the democratic rights of voters, had this to say.
The court has to take into consideration the democratic process, which clearly provides for the citizens, whether of Guyana or any other country, have a say in the process. And if the action of the court or the decision of the court at a time when the elections are over and a decision of that nature is made, it may very well have the effect of disenfranchising part of that population.
The Attorney General, Basil Williams, in responding to a question posed by the court, submitted that Articles 163 and 177 of the Constitution of Guyana do not conflict each other. He explains.
There's no conflict, Your Honors, because under 163, that deals with the elections of members of the National Assembly and also the allocation of seats, etc. But the president is not a member of the National Assembly. So the president, no question involving the president could be taken in the High Court in relation to the exclusive jurisdiction of that court. That's why there is a separate and exclusive jurisdiction to deal with the presidential elections in the Article 177.4, and that was given to the Court of Appeal. So there's no conflict in that situation.
Reporting for HGV Nightly News, Wendell Badrie.